Hi, I'm Ifoma Odolami. I'm an immigration attorney with the Odolami Law Firm. The topic of today's discussion will be conditional green cards. Conditional green cards are what you get when your U.S. citizen spouse files for you and the marriage is 2 years or less. And that's different from, of course, the permanent green card, which goes for 10 years, which lasts for 10 years. Now, the important thing about a conditional green card is that you have to remove the conditions before the expiration of the green card. So you're required to remove those conditions 90 days before the green card expires. The expiration of the green card will be on the green card itself. It will tell you the date of the expiration. Now, when you file to remove the conditions, you do that by way of filing an I-751. It's supposed to be jointly filed with your spouse. And I encourage my clients to bring in as much documents to prove that the marriage is a valid marriage and it was entered into in good faith, such as a lease agreement or mortgage, pictures showing family members. If you have children together, you want to bring their birth certificates. If you have joint banking accounts, life insurance, naming each other as beneficiaries, that kind of stuff. Now, sometimes the marriage doesn't last the 2 years, and in that case, can you still get a green card? Yes, you can. If your marriage doesn't last, either because you're divorced, or the U.S. spouse is deceased, or you can prove that you're an abused spouse, or that the children in the marriage were abused, or you can show that failure to remove the conditions would cause you extreme hardship, then you can request a waiver of the joint filing requirement. Now, the USCIS does not interview every conditional resident, but it certainly reserves its right to interview people that haven't met their burden of proof. If you need help with filing a removal of your conditions, always feel free to call my office at 973-993-1900.